I'm going to talk about the conservation authorities. Anybody know what a conservation authority is? Anybody had any run-ins? Conservation aggravation. They were, I guess, next to the OSPCA, which is very, very stressful and detrimental to people's health when you get attacked by them. I'd say the next one was the conservation authorities, as most devastating to people's lives. We've had at least 2 people die under their, continued abuse. And 2 of our local guys right here in this area, Terry Hale and Mike Wesley, both had heart attacks over their aggression and taking away their property rights and them trying to fight them on their own. But the intention of the Conservation Authority was pretty upscale whenever they started out this thing, and it was in 1932 they created the Grand River Conservation Authority, which was the Grand River running from Hamilton down to Lake Erie, I believe, and there was a lot of erosion, there was a lot of floods, and then in the summer there was a lot of drought and nobody had any water. So being that municipalities tried to look after these things on their own, it was very hit and miss how much municipality would do for the overall picture, because they didn't have the overall picture. So it was thought that by setting up a commission of some sort, they would be able to do the watershed as a whole, as an overview. And it was to protect private property, imagine that, and protect manufacturing, supply of water, protect water supply for drinking, and to protect against flooding and drought. So there was good intention in that. Now, in 1946, that was the first sort of kick at the can. And in 1946, they made it officially the Conservation Authority Act was the first one for the province. And it pretty much mimicked the Grand River Conservation Authority. So what went wrong with all this? With all that good intention to protect us, they were tasked with all the good things we want to do is look after the land and protect people's property and their value. And now, and I'll just go back to some of my notes, but all that good intention. So how did it become all these good intentions come to power tripping, intimidating, bullying, theft of private property through extortion in the form of demand for property permits? Now that's what's happening now. In the Nottawasaga, I can't say that word very well, but in Section 5 of their land acquisition policy, they said they would try to acquire land that was eligible for conservation land tax incentives. So if you were approached by your conservation authority on their planning, they'll sometimes approach you and say, listen, give us some control over your back swamp there, and you won't have to pay any tax on it. So the Nottawasaga Conservation, they thought they'd take it one step farther, and they said, well, why don't we buy that land or get somebody to give it to us, and then we won't have any tax burden because it's eligible for the tax relief from the province, and we'll have all this land under our control without any tax on it, so that'd be a great thing. Problem is, people weren't giving that land up very easy. They like to get the free taxes on it, but they didn't want to give it away. So and these lands are provincially significant wetlands, Niagara Escarpment area designations, habitat for endangered species, and community conservation lands. So it's a lot of property, and they're wanting a chunk of it all. So what they decided to do, they would put it into the permit process. Now, some of you folks have run into that one by now. And by the way, most of this stuff here I'm talking about is in Liz Marshall's Conservation Authorities, the legislators' intent, which you can grab out here in the hall. And it's in a lot more detail than I'm going to do it today, because she goes through each of the acts line by line and interprets them for you. But they decided to do this a permit approval process, which they said they could do under the Section 28 of the Conservation Authorities Act. The only problem is with the Section 28 is it refers to property that the CAs own or have entered into an agreement with property owners for. Section 28 does not give them the right to make regulation on private property. As a matter of fact, you have to go back to Section 21 of the Act, which is the sequence you need to follow, not just pick out of the midair a line that you want. And in Section 28 of the Act, it says the CAs can enter into agreements with owners. That then is registered on title, on title of the land, and or by signed contracts. Now that that's done, now Section 28 comes into play. It does not come into play before an agreement of some sort comes on private property. So on private property, they don't have any authority. There's no place for them. The authority the CAs have been professing could not be granted to them in the first place because their authority comes from the M&R, Ministry of Natural Resources. Okay? They are the Crown representative. And if you go on the M&R's website, and you can pick these up here, we got some up the front here, their very own website. And it says the sale and issuance of letters patent. The Ministry of Natural Resources does not retain future options for the land and does not control use. Rights granted by a patent are transferable by the patentee through sale. So those patents, if you bought the property, they come to you intact unless somebody else has made a deal with them in the meantime, and so you have to have somebody do your title search. Gord Turcotte comes to mind. And so in that sense, in the website, they are telling you that the conservation authorities has no power to have control over your property because they didn't have the power. M&R didn't have the power to grant to them. And they are their overseer and their power giver. These are just a corporation. Conservation authorities, just a corporation, nothing more, nothing less. So does Canadian Tire have control of your private property? No different than a single person having control of somebody else's private property. Can't be done. They don't allow it. It's not in the scripture in the Constitution. So from that point of view, we are very confident that there's no power vested in the conservation authorities to have any control over private property unless you let them. Now, that's why they do the permit process, and Ottawa's right in that one, and most of the other communities as well. So you go to get a permit for your house. Now you have to go to the conservation authorities to get a permit for your septic tank, or your septic bed, or whatever it is. And at that point in time, you've invited them in. So they set the system up to their advantage. Now, I have a fellow, well, I've got a few guys around, but a lot of calls, but one particular case is pretty erroneous. It's out at Kempful, and a fellow had a chunk of land he was developing, and he's done it before. He's been in this business for a while, and there was some lower land around it, all right, there's no doubt about it, but he was trying to create a municipality out there, and the school board came to him and wanted to buy 18 acres for a school. And so he approached the municipality to get a permit to sell him 18 acres. And they said, well, you have to talk to Rio Valley Conservation. You know, they whatever they say goes. Well, they said they would not give him a permit unless he gave them a section of the property as wetland. And it wasn't a little section, we're talking like 50 acres of stuff back, of stuff. And that's extortion. You know, it is holding him ransom for a permit that has nothing to do with development or anything else. It's his property. They don't own it. But the municipalities are in bed with these folks in setting these rules up and allowing them to extort money from people, and not just money, but land. So I think if it's challenged properly, there's a win there. But you have to realize that if you sign this thing, you lose your 50 acres. It's gone. And people often do that because they don't want to jump through all the hoops. Now, I got a young lad there standing there with a red jacket on, Bob Ralph, and he had a piece of land at Richmond a couple of years ago, and they redone the floodplain in Richmond. They decided that the old floodplain wasn't working for them. This is the city of Ottawa, and the village association was part of this as well. They were trying to stop development around them, and so they were trying to throw up roadblocks for developers. And so they asked for the city of Ottawa to do a reassessment of the floodplain. So they got one consultant, and he said, no, the floodplain's good. We like it the way it is there. It's exactly where it should be. And so they didn't like that one, so they got another consultant, and yeah, no, the floodplain's right. We had it mapped all right the first time. And so they got a third one, and this guy said, oh no, it's all wrong. We moved the floodplain back about 3 miles, from the river. So that's the one they wanted, that's the one they took. And so that put Bob in pretty dire straits because he had a little wedge of property along the side of a municipal drain. And it was 30 meters wide at the front at the best, going back to, 10 acres or so. And that's the only entrance for the property. And right away they said that, you're in the floodplain, so therefore you can't get an entrance there. Well, when they did their mapping, they didn't notice a big mound of ground that had been piled up years ago. It was a pretty big mound of topsoil. And so I suggested to Bob to put a berm right up the side of the river, up the side of the bank of the creek. And lo and behold, the next day the hi-ho was in there, and that was done. And shortly after that, he got a call from conservation authorities. Can't imagine why, but anyways, they wanted to meet on the side of the creek and scold us and scold Bob and tell him how he's going to have to change everything because he disturbed a floodplain, and he had to be back 30 meters from the side of the creek. And so we met there on a miserable cold day, and they brought their biologists and their enforcers and stuff like that with them, and proceeded to tell us how bad we were. And anyways, we finally let them talk for a while, and then we asked them where the legislation said that you couldn't do that. And they stumbled around a bit, and they said, well, it's the law. It's the law. Well, we said, show us. Sure, if it says you can't do that. You can't be within 30 meters of a creek and touch anything. And they didn't have it with them. And so I suggested to them they didn't have it because there was no law like that. And the 30 meters is a Department of Fisheries and Oceans suggested setback. It's a suggested setback. It isn't the law. It means that if you plow in the field and you're out from the creek 30 meters and it all rushes and floods and all flows into the creek, you're not going to be charged with wrecking a fish habitat or something like that. But if you go and plow the side off the bank of the creek, maybe they have some standing to charge you. But it's only a suggested setback. Really, it's not. You'd have to be really intentionally doing that, doing something to destroy the thing. So whenever we brought that up, of course they stopped talking and they went home. And Bob went down to the Rio Valley meeting the next week, and Glenn Brooks was the councillor at the time, and he spoke towards the problem down there, and all of a sudden, Bob's problem went away. His berm was fine. still there. Bob's still got his property, still has an entrance. So the bluff was called. Now, we had another similar situation, just happened last fall actually, just at snow time. A young fella, a landscaper, had bought a piece of property near Ashton. And it was an acre, 1.1 acres, I believe. It was a low piece of ground, no doubt about it. But he went to the city of Ottawa and asked them, it was an old lot, it had been sitting there for years. Went to the city of Ottawa and asked them if it was a building lot. The city of Ottawa said, absolutely. That was severed many years ago. It is a building lot. You can build a house on there. But you have to talk to Rio Valley. So this young lad had quite a bit of topsoil left over from some of his jobs. So he brought a few loads of topsoil in and proceeded to bring it up. Now, there's a ditch along the road, and there's a ditch along the side of the property going into it about 6 or 7 feet, I'd say, into this 1 acre lot, maybe 10 feet, at a pretty short angle, so it doesn't run right through it. And he put a culvert in at the road, and of course he had to get a permit from the city of Ottawa to put the culvert at the road, so that was done. But then he started to fill up the lot, and he filled it up about 3 feet deep. And about halfway through that process, even less than that, he was left a notice on his property to cease and desist from Rio Valley. And so he called Mike Wesley, who is our lowland guru up around our country, and wetland guru. And Mike says, well, I'll bring you up a sign and put it up there. And we bring up a landowner sign and put it on there and just keep on trucking. Which he did. And so he got another one of those notices, and he just kept on trucking. And then he got a registered letter in the mail and said, we're going to charge you for destroying the wetland, and you better talk to us now or you're going to court. So Mike was talking to him, and he wondered, so he had a meeting down at Rio Valley with their officers down there, and Mike volunteered that we'd come with him. So Shirley Dolan and Mike and myself went down with them, with this fellow, to discuss the problem. And they were pretty surprised to see us walk in with them, actually, because they sort of got to know us now. So we sat down and I listened to their spiel, and it was Don MacGyver of the Rio Valley Conservation, and he scolded this young lad pretty hard. Told him how dumb he was to go and do such a thing as that without getting a permit. You know, if you'd have been a lot less trouble for you if you'd have went and got that permit, and we didn't go through this stuff today. This young lad was pretty calm, and he said, well, would you give me a permit to do that? He said, no, I wouldn't give you a permit, but he says you wouldn't have to take it all out either. Well, the young lad says, well, you know, that's not working for me. And so that sort of stalled it there. And he anyways, they were still very forceful and saying, you know, there's a 30-meter setback. You cannot do anything of that. So you're talking 30 meters back from the ditch at the road and 30 meters back from the ditch on the side. Now, if you take that up an acre's lot, you can sort of imagine what your backyard's going to look like, you know. Where are you going to put your house and your driveway? But so I at this point said to the enforcer officer who had been on the bank of the creek with Bob and I said, I turned to him, he was sitting directly across from me, and I said, now, you and I have been through this before. I said, show me where it says 30 meters setback. I said, you and I have been through this before. And he just dropped his head, didn't say anything. And I turned to the other fellow, I said, show me the 30-meter setback. He said, that's the rule. I said, this is private property. Well, he had a bird at that one. And he said, we're not dealing with private property. You know what you guys are about, you know. So, and he turned to the other young lad, the landscaper, and he says, if you want to get something done here today, you better not listen to these guys. We were going to get this fixed. You want to get it done. And the young lad said, that 30-meter setback's just not working for me. And